This is the Serta Simmons case, which was a lender dispute. We represented certain lenders led by Apollo Management, Gamut, and TPG Angelo Gordon. And we were known as the excluded lenders because we were excluded from a transaction done by the company Serta and another group of lenders that were referred to as the participating lenders. And we were challenging the transaction, asserting that it violated the parties' contract. Well, the Serta transaction itself was the first major liability management transaction of the pandemic era. And this led to a flood of these types of transactions that often favored one group of lenders over another. And this decision really changes the risk calculus for those lenders, because if they're going to engage in this transaction, they have to now go with the knowledge that they may be held liable and may be coming out of pocket in a lender versus lender dispute. I think everything about the posture of this case says something about the toughness of Quinn Emanuel and how we can litigate cases. We were brought in just a few months before trial. There were significant discovery issues outstanding, and it was a very complex, cutting edge issue of contract law. And again, in the context of a bankruptcy case where the bankruptcy was finished and everyone wanted to move on, but our clients' rights needed to be vindicated. And so we had to jump in and really take ownership, each member of the team, of a part of this case, but always balance that with keeping the collaboration and making sure that we knew exactly how it was going to fit in to the whole trial presentation. It was almost like trying summary judgment and trial at the same time, because we were arguing about the language of an agreement and using all the evidence that we could marshal from within the agreement itself and otherwise to prove what that agreement meant, while at the same time knocking down each of the defenses that the other side raised, some of which had never been raised in this context. We were able to establish what the contract meant, that the other side breached it, and how we were damaged. And we did it in a very cohesive, simple way, walking the court through it. And I think that appeared a lot in the decision the court rendered.